CLPR, the Center for Law and Policy Research, welcomes you to the fourth workshop of the US-India Comparative Constitutional Law 2.0 series. CLPR is a nonprofit organization dedicated to making the Constitution work for everyone through law, policy, research, social and governance interventions, and strategic impact litigation. This project is in furtherance of our Constitution culture initiative. This initiative is aimed at creating public awareness and creating active public engagement with India's constitutional tradition to build a popular constitutional culture in this country. Over the years, this initiative has widened in scope to include our website, public events, and conferences. Our constitutionofindia.net website curates debates that took place in the Constituent Assembly leading up to the framing of our Constitution. We encourage students who are interested to visit this website to read, search, and explore more about India's constitutional history and practice. The purpose of this particular project is to help students understand and appreciate the constitutional traditions of India and US. Through these sessions, we aim to create increasing engagement and appreciation of the US and India constitutional law and facilitate collaborative constitutional understanding and exchange of ideas amongst Indian and American law schools. I would like to thank Professor Aparna Chandra and Professor Adam Fiebelman for partnering with us, supporting this project and bringing all of this together. I also would like to thank all the professors who've joined the call and Professor Mark Tushnet, who will be the keynote speaker for this particular session. We also would like to extend our appreciation and thanks to the US Consul at Chennai for all their support, specifically Ms. Nita Davalur, who's also joined the call today. It would be great if all the professors and whoever is a part of this call could join in our discussions today, just to make it more enriching. With that, I think I will just quickly give you an idea as to how the session is structured today. So we've divided the session into two parts, as we did the earlier sessions. Part one will be a summary of readings and then a student discussion. Part two, also summary of readings by CLPR and then a student activity, after which we have remarks by Scott Hartman, a US consulate officer, as well as followed by the keynote speaker, Professor Mark Tushnet, and then we will be closing the session for today. I think we can dive right into part one of this, so we don't waste any more time. If you have any questions, please feel free to ask us at any point. Malvika and I are more than willing to answer them, and I'm sure we'll be having most of the questions addressed during the activity and discussion sessions as well. So part one of the session is going to be just to give an idea to all those who are a part of this session as to how the executive structure, both in India and executive distribution of powers, is in India and US. So Article 52 states that there shall be a president of India. We then have Article 53, which states that the executive power of the Union is vested with the president. So this vests the executive power with the president. We then have Article 74, which states that the Council of Ministers with the Prime Minister will aid and advise the President in exercise of these functions. We also have a similar setup with the states. So the next article is the one that states that there shall be a governor for each state. We then have Article 154, which states that the Council of Ministers, as well as the Chief Minister, who has a similar power to that of the Prime Minister, but at the state level, will aid and advise the governor in the exercise of his functions, which is 163, while 154 states that the executive power of the state will be vested with the governor. And just to give you a better understanding of how the executive setup is in India, we've pulled extracts from the Sarkaria Commission report, which is a report written about the inter-union and state relationships, specifically talks about the executive setup as well as the legislative setup. So in this particular report, it goes on to talk about how the union executive consists of the president, the vice president, and the council of ministers, with the prime minister as the head to aid and advise the president. In India, the president is the formal head of the state, and the prime minister and the council of ministers who are the ones who run the government at the national level. At the state level, the executive comprises of the governor, the chief minister, and the council of ministers. So the Constitution of India vests the executive power of the Union formally in the president. In reality, the president exercises these powers through the Council of Ministers headed by the Prime Minister. Now, the executive function comprises both the determination of policy as well as carrying it into execution, the maintenance of order, the promotion of social and economic welfare, and also carrying on supervision of general administration of the state. Similar to the union level, the state executive power is also vested with the governor. Varsha, can you show us the next slide, please? Right. So the Constitution envisages that there will be a governor for each state, and the governor is appointed by the president. Again, as I said before, the executive power of the state is vested with the governor, who then exercises his functions through aid and advice of the Council of Ministers, as well as the chief minister of every state. I will now quickly also take you through the American provision, which is the Article 2 of the US Constitution. The power of the executive branch is vested in the President of the United States, who also acts as the head of the state and the commander-in-chief of the armed forces. The president is responsible for implementing and enforcing the laws written by the Congress, and to that end appoints heads of the federal agencies, including the cabinet. The vice president is also part of the executive branch, and he or she will be ready to assume the presidency if need arises. Now, at the state level, the executive branch of every state is elected by, is headed by an elected governor. And most states in the US have a plural executive in which several key members of the executive branch are directly elected by people that serve alongside the governor. Each state government is free to organize its executive departments and agencies in any way it likes. And this has resulted in substantial diversity among the state with regard to every aspect of how the governments are organized. Thank you, Asha. You can move to the next slide. Yeah. Now, the vesting clause. So the reason we used this particular reading to complement the articles of the American Constitution is that we thought it will sort of give a sense of how the vesting clause is read into and will aid our discussion question, which we will come to in a bit. So the vesting clause establishes a unitary executive and it creates a single executive president. Now, we know that throughout American history, a lot of scholars have argued that this is a minimal sense, the minimal sense exhausts the content of this clause. And others, on the other hand, have also argued that the clause does more and actually grants precedent entire executive power. And this position is often identified as the unitary executive approach. And the two approaches obviously have various disagreements. So the first one is whether the term executive power identifies a set of powers beyond those expressly identified in the Constitution, but are nonetheless given to the president by virtue of the vesting clause. Now, minimalists often claim that there was no settled meaning to the term at the time of the founding, and that executive power of the United States only refers to those powers elsewhere assigned to the president. While on the other hand, the unitary executive position is that at the founding, executive power referred to a huge range of powers, such as the powers to execute law, appoint officers, communicate with foreign governments, formulate foreign policy, wage war, and such. The second disagreement is whether by vesting powers in a singular executive, does the vesting clause establish that the president may exercise these powers by himself without interference by Congress? And does it give the president the authority to direct and supervise any federal official involved in such matters? So the unitary executive position, they often assert that the president can exercise his constitutional powers without any congressional interference and that he may direct executive officers, while vesting clause minimalists claim that Congress, through the exercise of its legislative powers, including the necessary and proper clause, can qualify or regulate the president's exercise of powers that have not been clearly assigned to his sole discretion, as long as the Congress does not impede the president's ability to discharge his constitutional duties. Judicial doctrine on this is mixed, so I'm not going to entirely get into that. But what's important is that arguments about this particular, about the vesting clause surface when the government takes actions that might not fit within the existing understanding of how the Constitution separates powers in the US. So now that we've taken a look at these provisions, we were actually curious to see what the difference between the two countries are, specifically in the way the federal distribution of executive powers are. And we thought a fair way of maybe jumping right into that is by maybe helping the Indian students understand how the federal distribution of executive powers is in the US, and that could possibly be done by one of our American students. So please take 2 minutes to sort of think through the question and see how you want to answer it. And it'd be great if we can have somebody start off with the American distribution of executive power.
We need to sort of take a step back and maybe think about why executive powers have been sort of divided in the way they have been in India and the US. What could be the purpose behind this division of executive power? And maybe once we sort of take a step back and think about what the broader purpose can be, we can sort of tease out differences between the American system and the Indian system. So please feel free to jump in, NLSIU students and Tulane students. We would absolutely appreciate hearing an American perspective as well. Mansi?
Good evening, ma'am. So I think the federal distribution of executive power in US, where the executive power rests with the president, is much wider when compared with the Indian counterpart, because their president has wider powers. He is not always required to consult with the Council of Ministers, as in the case of India. And he can also take independent decisions where, like in India, even if the president asks the legislature to review the law once again, if the legislature says that the law is to be remained as it is, the president is bound by the advice of the Council of Ministers and the legislature. Whereas in the case of America, they have wider veto powers as well. The president has wider veto powers as well. So I think the executive power in US is much broader than what is there in India.
So I think what you've provided us is a sort of useful assessment of the president's power in the American situation, but specifically with respect to the federal distribution of powers between the federal government and the states. Do you think that there is a significant difference between the way it's been distributed in the US vis-a-vis India?
Yes, ma'am, I think there's a huge difference, and that is because of this only, that that larger powers vest with the executive in the US Constitution, whereas the power in India is restricted when it comes to the executive. So that's it. It's broader in the US context and restricted in the Indian context.
So if I can jump in, I think, and I'm speaking for myself, but I think one of the things that's challenging in comparing these two arrangements, at least from an American perspective, is given that in both systems, the executive power is defined in many respects or a function of the relationship with the legislature, the parliament. One has to kind of understand what that relationship is and how the executive power is defined in important respects by acts of the legislature. And I think, again, speaking for myself, most of us in America don't understand very well what that relationship is in a parliamentary system, and how that in particular helps define what we're thinking of as the executive power. And particularly this relationship, not just of the legislature, but of the ministers and the president, I think is difficult for people familiar with an American system to get one's head around.
Yes, George, am I pronouncing it right?
I'll just chip in with a very brief observation. Comparatively speaking, the Indian system seems interesting because from a European perspective, the one country that kind of seems similar is France, and France has a president, but France also has a prime minister. That is not necessarily the case in other parliamentary systems, or should I say, systems with a parliamentary controlled executive like Germany. In Germany, we have a president, but the president plays no role. It's the chancellor, which would be the equivalent of a prime minister in the United Kingdom. And again, in the United Kingdom, which is a parliamentary system with strong parliamentary control of the executive, at least on paper, there is no intermediate area between the executive and parliament. Now, in France, you have a prime minister, you have a cabinet, and you have a president, and they're both part of the executive branch. But of course, the prime minister is very much tied to parliament, to the National Assembly, and needs the confidence of that body if legislation is to be passed. And at the same time, you have a president who's insulated from parliament, much in the same way that I would expect it to be in India. So back to the US. In the US, we have a strict separation of powers, a much stricter one than we find it in continental European systems, for example, or the United Kingdom. But it is characterized by a single executive head, the president. The focus is on the president. Now in India, and that's something I would kind of throw into the mix for students to discuss, we have a president and a prime minister, as in France, a president and a prime minister. Whereas if you move to parliamentary systems, UK, Germany, just a prime minister, just a chancellor, that is different. And that speaks to what Professor Feibelman just kind of raised, this relationship between the legislative branch and the executive branch. Obviously, the US and India follow different patterns in this respect.
If I can jump in here, just to say that India is closer to the UK than to France, I would imagine, because the president is, in some senses, very close to the Queen. In terms of the powers that the president has. The idea was to move away from a monarchy to a republican form of government, and therefore you have a president who is indirectly elected. So it's an elected office, but it's an indirect election. But in terms of the conception of the powers of the president, and there is some question about, whether the president has broad or narrow powers, how broad or how narrow, but the imagination very much was of the president being, in some senses, a titular head of state, with the actual locus of power being the prime minister and the council of ministers. So in that sense, India actually directly borrowed from the Westminster style, parliamentary style of governance, which is what the framers were used to at the time of independence from Great Britain, from the UK. So that is so just to say, I would think that India is closer to that, but I agree with the point that unless we get a sense of the relationship between the executive and the legislature, as well as there are lots of nuances of the relationship between the central government and the state government. So for example, something that wasn't mentioned was that the governor of the state is appointed by the central government, and that too by the central executive. Some of those elements shape the relationship of the federal executive with the state executives, and I'm not sure that we would have enough information. I can definitely speak from the Indian side that we've put on the table enough information to really evaluate from a comparative perspective how that federal division of powers works out in the US versus India. So perhaps I don't know if someone can chip in with more information on the Indian system or the US system, as the case may be. I think as a group we'll be in a better place to collectively think about the comparison.
Satyajit, your hand has been up for a while. Would you like to sort of summarize the Indian position?
Sure. So before that, I had a point to make, which is basically what Professor Chandra just said, one point of comparison that we could look at is the role of state governors. And what we can see in India very often is that the state governor becomes like a tool for the central government to exercise power in the state. So one example that I was thinking of was when it comes to West Bengal, which is currently ruled by an opposition party. Very often we see the center trying to use the governor as a way of exercising influence. So let's say in terms of granting sanction for prosecuting agencies and so on. In terms of summarizing the Indian structure, so you have the president who is the formal head of state, and then you have the prime minister and the council of ministers who exercise real power. And the president is, although vested with executive power under the constitution, he exercises his functions according to the advice of the council of ministers. And the union, this is a similar relationship in the state, except the only difference is that in the state you have you have the center appointing the governor. And as we read in the reading over there, the idea was that they wanted to preserve some sense of, let's say, unity, and you didn't want to have elections for the state governor as well. So that's why you had the center elect the governor over there.
Thank you, Satyajit. Yeah, I kind of understand what the difference that you're bringing out. But I think maybe we could move a step back and sort of try to put forth what the Indian setup is. So maybe Vishank, could you help us with that, and then we could move forward.
Sure. Just in terms of what the Indian position is, as I understand it, the idea is effectively that the executive power, in terms of the federal distribution, is coextensive with the legislative power itself. So, as in the previous discussion, for those from the US students are here, much like there is enumerated powers for the federal government, India has enumerated powers for the state and the central government. And the idea is that the executive power is coextensive with that enumeration of powers that exists for legislative power, though there are a bunch of different exceptions that apply. So in some cases, for instance, when there's an emergency, the federal government can have some powers over the state. For international treaties, for instance, the central government can exercise certain executive powers, even if it infringes on state executive power. So there are a bunch of exceptions, but broadly, the idea is that the federal distribution reflects the distribution of executive power as is there for the legislature. One of the differences in terms of who executes that law or enforces that law. So you can have three different options. One option is that you can have a federal law that is purely going to be enforced by federal agencies. The second option is you can have a federal law, but the enforcement of that federal law is left to the federal agency. So for instance, you could have a special criminal law at the center, but the enforcement of that is the state police's job. And the third is you could have like a mixed system where part of the functions under a federal law are with a federal agency and part of it is left to the state agency. But the state agency is, of course, bound to follow the federal law. So that's sort of how it happens with respect to the executive power. I actually just had a quick question. It's a very basic question, but I don't know how this is understood in the US Constitution. But in India, for instance, it very explicitly says that the powers of the executive are coextensive to the legislative power. And I see that in the US Constitution, you have like the distribution of legislative power between the states and the center in Article 1 and executive power in Article 2. But Article 2, from what I can see, doesn't really talk anything about the federal division of executive powers explicitly like the Indian Constitution does. So I was just wondering, how has this been interpreted in that? Is the executive power just implicitly understood to be coextensive with the legislative distributions of power, or is there a different understanding in the US?
Would someone from Tulane like to take that question?
Well, I hesitate because it's a big question. But I would just say that I think that one's answer to that question depends in part on where one falls in the debate that was described earlier between kind of how one conceives of the executive power to begin with. But certainly, if one has the minimalist view that was described or is along that spectrum, then the kind of conventional understanding is that Congress makes the laws and the executive enforces the laws that Congress makes, except for a few areas where there are, discrete powers given to the president, so that so that's the one thing. And then one talks about how this plays out in a federal system, so that the president's power of in with regard to the states, that gets even further complicated, because one then has to understand how federal law can preempt state law, and the president is then enforcing laws that Congress has made that preempt state laws or don't. So there are kind of these two moving pieces. One is, what is the power of the president in general vis-a-vis the legislature, and the other is, what is the power of the central government compared to the states. But I think the conventional view is that Congress has the power to make laws, some of which can preempt state power, and the president is then enforcing through agencies as well, which I think we should probably talk a bit more about agencies and the administrative state in these two countries. But then those entities can preempt state power to the extent that Congress was within its power to do so. And I said a lot there, and I'm sure I got some things, that was an oversimplification, but hopefully enough to further the conversation.
Thank you, Professor. I think that definitely sort of provided us with a better idea. And I think one thing that I sort of wanted to pick up on was the role of agencies, because when we were sort of reading, we were we found the idea of federal agencies quite interesting. And the kind of powers that have been vested in the agencies seem to be greater than the powers that we would have for Indian equivalents. So I just wanted some sort of clarification. So there are agencies at the federal level and there are agencies at the state level as well, right?
Yes. I mean, generally we have these, the kind of states follow the same pattern, where there's a state legislature that passes a law, and then the governor of the state is the equivalent of the president at the federal level, and the legislatures at each level may create agencies in their lawmaking powers. But then those are staffed we think of those as part of the executive branch, because the president at the federal level and the governor at the state levels are in charge of making sure those agencies do their job and directing them, at least to some extent, subject to debate in terms of what the scope of the executive power is in that context. I hope that's helpful.
Yeah, that's helpful. That's definitely helpful. I think that we sort of, it's an interesting aspect of the American system that we don't quite have an equivalent to here. So it's definitely interesting and helpful. I think Yash had something to say.
Yes, my point was just in regard with the fact that how the two systems are very different, that in the Indian setup, the president and the governors are not equivalent at the center and state levels respectively. Because if we just have a reading of Article 74 for the president and Article 163 for the governor, the exercise of discretionary powers which the Constitution ordains for the governor is perhaps completely absent for the president, right? And so to that extent, the role of the governor is much broader. One, second, the idea that constitutional practice has also shown, and the structure also demands that the governor is not only the head of the executive in the state in India, but is also an agent of the center in the state, and is there to maintain that kind of integrity of the nation, right? Which is not the case, to my understanding, in the United States, right? And third, in terms of pure political practice, the governor is also seen as an agent of the political party or coalition that is running the government, at the national level in terms of allowing for midnight oath ceremonies or early morning oath ceremonies, allowing chief ministers to be sworn in for less than 24 hours, etc., are again things which completely distinguish the Indian practice, and also the fact that their role in terms of the constitution is different because how often are they bound by constitutional propriety is also a deep question, right? So Sarkaria Commission or the Punchi Commission report and all others. And what it suggests today is that the role of the governor is in the gray in India, right? And it's best left undefined because perhaps that's suiting the status quo. And comparing it with the United States, I think it's much more clearer. We have an elected governor, powers are mentioned in the Constitution. Cases of constitutional excesses, to my understanding, are much limited. Yeah.
Thank you, Yash. It's interesting that you bring in the differences from the governor, because something that we were discussing was also about where the state executive gets its power, both in India and US, because we have it enlisted in our constitution, but the US doesn't specifically have that. So we were just also talking about how that's a difference. That's maybe something we can get to at a later point in the discussion. I see, Professor, you have your hand up. Maybe you want to speak next.
Yes, just two comments. Again, to perhaps just simplify things, there are two choices. You can try to mix two levels of governance, federal, state, or provincial, or whatever you might call it. And you can try to keep them apart as neatly as you can. Now, the US is a good example of trying to keep things neatly apart, two separate systems. And Professor Feibelman explained that the governor is somewhat the equivalent of the president at the state level. And Yash said, yes, the governor in the United States is elected by the people. So kind of a dual system. You have the federal side, you have the state side. Each state can organize itself, has its own constitution, and can deal with the details of its internal organization autonomously, which does not seem to be the case in India. So one calculus is kind of, let's keep things apart, separate. The other is to intertwine things. And the governors in India seem to be one element of trying to intertwine things and giving the federal level more reach into the states, which, by the way, without drawing the comparison, neatly reminds me of the prefects in French departments, who are a local kind of executive authority controlled by the central level in Paris. But the second point I want to make may be more interesting, and that is one aspect. How do systems evaluate, let me use that word, or what significance do they attach to the power to execute the law? Now, again, in the United States, broadly speaking, the authority that legislates will execute, with a lot of gray areas in between preemption. Professor Feibelman spoke about that. India seems to be a system where there's more legislation at the federal level, which is then executed at the state level. But I'm open to be corrected there, which reminds me of the German system. The German legislature at the federal level legislates nearly everything, but executes nearly nothing. The administration is left to the states. So that begs the question, what significance do we attach to executing laws, to actually administering laws? And in the United States, states seem to be very protective of that power. In other systems, this power to execute a law, and in many cases it will be federal, is regarded as a different way of separation of powers. And you have that in Germany, which is a very different federal system from the United States. And it seems to be similar in India, where the states are given significant executive authority.
Thank you, Professor, for that. I mean, we were wondering, since we've had none of the American students put forth their views, if there's anybody who put their view, and then maybe we can get to. I'm not sure if I'm pronouncing your name right. Is it Ian Jan? I could be wrong, so please forgive me. Would you like to share your thoughts on the discussion?
To be honest, I'm just a German student in the US, so I don't really have to contribute much about the US Constitution, but I'd say that I agree with what Professor Fetke has said, that the US system is quite interesting in that differentiating of states and sort of the federal level. And I'd say that I don't know if that's a point relevant to the discussion here, but the US Senate seems to be sort of the equivalent of the Indian governor, where the states sort of historically put their representatives instead of like now the government, or like where they're represented in the federal level, I think. And I think that's sort of a neat comparison, because there the states put their thing up, or their representative up, and then at the Indian level, the representative goes down to the state level, I guess.
Thank you. Shank, do you want to continue?
Yeah, so this is just another difference that I think I perceive. Just building on Yash's point where he talked about the difference between the governor and the president. So I think one of the differences is also, and I might be wrong here, but I think it also depends on, because of the relationship between the president and the parliament, to some extent, the president's discretionary powers also depends purely on the balance of power in the parliament itself. So I think for the last 20 years, because you've very often had a very clear sort of winner in the center, like even with the previous government in India, the Congress, where you had a coalition, there was still a fairly powerful center. There was no one challenging whether or not they should be the ones ruling. But I think in the 70s or the 80s, where you had a lot of coalition governments and there weren't clear winners, I think the president in those cases, even if not legally, could in practice exercise a lot more discretion as the governor does, because at the end of the day, it's the president who's inviting for the formation of the government itself. So at least to some extent, and this seems different from the US, the executive power, purely in terms of the president's power, also depends upon the political play within the parliament. So I think that's another point of difference.
Aparna?
Moving from differences to similarities, I think a phenomenon that many countries around the world are seeing across different kinds of systems is the expansion of executive power, whatever be the formal division of power, separation of powers between the executive and the legislature. And of course, in the US context, there's the whole fear of the imperial presidency and the expansion both of the war powers of the president, but also otherwise just the expansion of presidential and executive power, including through agencies, through federal preemption, so on and so forth. There's this entire concern. And in India, which is a parliamentary system where formally the executive is responsible to the legislature, and the executive stays in office only when it enjoys the confidence of the legislature. In practice, we know that the executive's powers has expanded quite significantly, some of it through judicial decisions, such as the one in India where the Supreme Court said that the executive does not need the authorization of the legislature to act upon a particular issue area, right? So even if it's if its powers are coextensive with that of the legislature, that doesn't mean that the legislature has to authorize the executive to act in a particular area. Absent legislation in a particular area, the executive can always act as long as it does not contravene any other law or, of course, the Constitution. So that's given the executive quite significant powers. And because the executive controls the majority of the legislature, it is in the interest of the executive to actually not bring laws up in the legislature so that it gets free play. The other thing that's happening, and again, that's the global phenomenon of globalization, internationalization of norm making, is influencing the balance of powers between the executive and the legislature. And that's something to think about, where the executive may have to come in, make certain promises or make decisions at the international level, or implement decisions that are taken at the international level at the domestic level. And while India and the US follow different ways of engaging with international law, definitely in India, Parliament and therefore the executive has the power to act on any issue that is the subject matter of a treaty, and that very fundamentally shifts the power from states to the center, and since it moves to the center from the legislature then to the executive. So both globalization has an impact on the shift in power between the legislature and the executive on the one hand, and from the center to the state on the other hand, and the general tendency across the world, and that's a concern with declining democratic traditions, the rise of authoritarianism, so on and so forth. We could think about what the explanations for this is, but the expansion of executive power, regardless of the formal arrangements of separation of powers and distribution of powers, is something that we should think about, which may mean that in practice, India and the US might look actually more similar than the institutional arrangements would otherwise suggest.
Aparna, that was an absolutely wonderful sort of way to conclude this particular session, because our activity in the next session actually sort of touches upon a lot of what you're saying in terms of the expansion of executive power. So we will actually move on to the next session, and we will sort of keep what you're saying in mind as we address our activity. So I will be doing this session in which I talk about two case studies, basically from India and the US. The first is a question of net neutrality in the United States and the kind of executive orders that have been coming out in this context. So we know what net neutrality is. It's a concept that internet service providers treat all internet traffic equally. And net neutrality has been quite a contested sort of concept over the past decade or so. And in 2015, this was under the Obama administration, the Open Internet Order was issued. They're also known as the net neutrality rules. And they considered internet service providers a public utility and subjected them to some form of regulation that prohibited them from blocking or slowing web traffic or providing paid internet fast lanes. This basically sort of reinforced the concept of net neutrality. But in 2018, what happened was that this order was repealed. And what the FCC, the Federal Trade Commission, sought to do, was that it tried to preempt state and local laws that impose net neutrality regulations. So what the FTC did was that they said that they would not disturb or displace the state's traditional roles in policing such matters as fraud, taxation, etc., as long as the administration of general state laws did not interfere with federal regulatory objectives. So what happened next was that attorneys general from 22 states, including the District of Columbia, filed a brief asking the US Court of Appeals for the District of Columbia circuit to reinstate the Obama administration's net neutrality regulations. That is the 2015 regulations. So first, they argued that the second set of regulations, that is the 2018 regulations, the repeal of the 2015 regulations was arbitrary and capricious, and that it would harm consumers, public safety, and existing regulations. They also claim that the FCC was not authorized to preempt state and local laws. So what states did in response to this 2018 order is that they began to issue executive orders and proposing resolutions and bills to, in a way, resist this order. So what states did in 2018 was that many of them took action to support these net neutrality protections. So basically what these state governments did was that they said that the FCC did not adhere to the Administrative Procedures Act when it issued the Restoring Internet Freedom Order. So here in this case, we see that there is some sort of tussle between the executive and the state, between the federal government and the state when it comes to issuing these executive orders, and the kind of resistance that states have been expressing towards the federal exercise of these powers by the FTC, which is a federal agency. So the next case study is in the Indian situation, and it is about the Border Security Force powers and jurisdiction. So the Ministry of Home Affairs in 2021 sort of increased the jurisdiction of the Border Security Force within international borders in Punjab and West Bengal, and reducing this area of operation in Gujarat. So what the government did was, what the government sought to say, what the government said to sort of justify this jurisdictional sort of rearrangement, was to say that they wanted to bring some sort of uniformity in the BSF's jurisdiction across states. And what the Punjab government and the West Bengal government said, they tried to say that this was violative of the center state balance in that sense. They said that Punjab especially is a different sort of state where the situation is such that the BSF's jurisdiction being extended was not favorable to the state, because its unique circumstances made it sort of different in one sense. The Punjab government importantly also said that this violated the entries on public order and police in list 2, which we discussed yesterday, is the state list, and basically said that this encroached upon the state's authority to legislate on police and public order. So this is the BSF situation. So next we have an activity, and just like we've been doing for the previous two sessions, we will be dividing you into two breakout rooms. I'm just going to read out the activity, and then we'll copy paste the activity question into the chat, so you'll have it with you. The state of A in country X has an extremely high crime rate. The state of A has issued a new order for preventing crime in cities. As a part of the order, the government of A required all households to download a mobile app that tracks their movement at all times. Further, if a red alert notice has been issued, the members of the house must upload a selfie notifying that they are safe through the application every 6 hours until the red alert notice has been lifted. The union/federal government felt this new order was violating the privacy of individuals residing in state A. Therefore, it issued an order preventing states from mandating the downloading and usage of any mobile application without the consent of the president. The state of A is challenging the order issued by the union government as violating the federal structure, since law and order is a state subject. However, it is argued by the union/federal government that privacy, telecommunications, and data governance is a union/federal subject. The side of the challenge would succeed in how would the Supreme Court engage with this question in the US and in India? So we'll be dividing you into two breakout rooms.
The question is also on the chat box. So breakout room 1 could answer how the US Supreme Court would engage with this challenge, and maybe breakout room 2 could do it for the Indian Supreme Court.
And when we talk about how they would engage, we sort of hope that you will also serve as petitioners and respondents and sort of come out with the main arguments that both sides would advance in each case. Perhaps we can get started. I think that there was some sort of mix-up whether it's breakout room 2 and 3. So would someone from breakout room 2 like to go and sort of explain why they think this challenge would be sustained or fail, or how the courts would engage with this? Someone from breakout room 2? Anamika?
Yes, ma'am. So we basically we were looking at it from the Indians' perspective, and we kind of came to one of the ways of saying that the union government's decision in a way would stand, but not to the extreme of it. So we kind of thought about the pith and substance doctrine, and we tried to think about at the end of the day, because we were also having a discussion at the end that the object of what was happening was policing. However, what we were also discussing was like the usage of, or the, I would say that um, the basic intention was actually to ensure that, or to track everybody and to ensure, like, you actually upload a selfie in every 6 hours and whatnot, which is actually a basic violation of their privacy in its entirety. So we actually thought that that is something which, like, union government can actually get in their favor. However, the union government had actually passed the order saying that any mobile application without the consent of the president would not be launched or would not be mandated in that sense. And then Lakshmi pointed that out. So it was also about, maybe that is too extreme of a order that hasn't passed. Maybe that can be read down, and only to the extent that the privacy is being violated would be considered. If anybody else would also want to add.
Lakshmi, would you want to explain your point further?
Just that, like, sure, even though the broad, like the what the center is trying to do fits within telecommunications and privacy, the way that they're trying to do it is by banning the use of all mobile applications by the state. And that seems like too broad or something to fit within the mandate of what they're trying to do, and then could infringe on the states because of how broad it is. So it could be allowed to the extent that it is protecting privacy, because that's within the mandate of the center, but it shouldn't be to such an extent that it violates, not violates, but that it infringes the state's rights to police and law and order.
So I think your point is that it would partially stand in a way.
Yes.
So I'm very curious to hear what the US would do in such a situation. So can someone from breakout room number 3 sort of chime in and explain what they think the US would do, in what the US Supreme Court would do in such a situation, and the kind of arguments that would be advanced on both sides?
Break room 1.
Maybe if an American student could perhaps chime in and explain why they think this would, how this US Supreme Court would engage with such a question, that would be interesting. I think there was, yeah. So anyone from, yeah.
I'm happy to define myself as a student for this purpose. I think this circles back to some of what we were talking about in our first session, which is I think a lot would depend on the question says the federal government does this, and a lot would depend on how and through what arm or agency, like who it was doing it and pursuant to what kind of authority. There also could be a challenge at the Supreme Court of the state's authority to begin with that didn't necessarily implicate the federal government other than the Constitution. In other words, the state's actions could be, in both cases, I guess, constrained by the Constitution. But if the federal government, if we're acting through an agency, for example, which we think of as, again, part of the executive branch, then the question would be, was it acting pursuant to authority that was constitutionally granted to it by the Congress? I think that's at least one of the important questions that would be raised by this scenario in the U.S. Context. Those two questions: whether it was, whether each level of the government, state and federal, were acting within authority, and if so, then the federal government would likely preempt the state if it were acting pursuant to its authority. But I'm happy to be corrected by any of you who have other thoughts on that.
Would maybe Jonathan or Ian want to sort of step in and respond?
Yeah, so just for context, I'm not a law student, so I'm an economics student, so not really my not super familiar, but I mean, I guess there'd be issues on like both. I can see like the issues on both sides. I'm not sure what perspective like the you know, like what just what the Supreme Court would use in their decision making. But I do think it's interesting, I guess, you know, I guess like the conflict between the federal government and, you know, potentially issuing executive order preventing states from downloading and using that mobile application. You know, I guess people might like suspect that there's some like overreach there. But also like from the other perspective, like the state claiming that, or I guess like the original like issue of like, is this application, is the you know, requiring this application even okay in the first place? Is that like constitutional, or does that infringe on certain rights? I guess it's an interesting dynamic. I'm not really sure what perspective the court would take, but
I think that this preemption question is pretty interesting because when I was reading the case study on the FTC and their sort of their order sort of preempting state legislation, state executive action, I found that a pretty interesting sort of aspect of the case study. And I'm just wondering, I'm just curious about what our American participants, or perhaps Professor Feibelman, would respond to, and what he thinks could happen in the FTC's situation with net neutrality.
Well, I think that's a really interesting case study, and it raises two things that one that you mentioned and one I was going to mention as well. So we've talked about preemption a bit, and it's probably important just to step back and make clear that in our constitutional setup, federal laws preempt state laws. So if there are federal laws that are constitutionally enacted, then those would just in their operation preempt state laws. So that's a function of the relationship between the federal and state system. So if an agency is acting pursuant to a federal law, then anything they do, you know, or within certain bounds, but in general will preempt state laws. The other question with that case study gets back to this question of the status of agencies and administrative agencies in the administrative state that your Vice Chancellor, Professor Krishnaswamy, had mentioned, that I think is really critical to this discussion. And I was hoping to circle back to it and just think about whether we think of agencies in the US or ministries, for example, there as part of the executive branch or not. In the US, they definitely would be. It's a little unclear to me in the Indian context whether we think of ministries and the central government in that sense as part of the executive or part of the executive branch in the same way. But that's a little, I took the opportunity to nudge in a slightly different direction, so forgive me.
Thank you, Professor. I think this is a great place for us to sort of wrap up. This has been an incredibly interesting experience and form of engagement, and comparing two very different systems that perhaps can't be compared. But thank you so much. And now I hand the floor over to Kalyani.
Thank you, Malvika. Before we move on to our keynote speaker, we have Scott Hartman with us, who's the Cultural Affairs Officer of the U.S. Consulate General, Chennai. In his current position, he oversees a range of cultural, educational exchanges, grants, seminars, conferences, and other virtual and in-person activities, focusing on multiple global, regional, and bilateral themes, including human rights and democracy, inclusive economic growth, climate change, women's empowerment, global health security, fostering stronger Indo-Pacific ties, among others, with audiences across Tamil Nadu, Kerala, Karnataka, Puducherry, Andaman and Nicobar Islands, and Lakshadweep. Scott is also in charge of the American Center in Chennai and the consulate's English language program offered through the Regional English Language Office at the US Embassy in New Delhi. Prior to joining the US Foreign Diplomatic Service in 2003, Scott worked as an educator, teacher, trainer in Eastern Europe and Central Asia, and then as a journalist covering the United Nations and international organizations. Scott, over to you.
Thank you so much, and delight to be here with all of you. Namaskara and good morning to those participants tuning in from America. So whatever time zone you are in, welcome. On behalf of the U.S. Consulate General in Chennai, I'd just like to thank all the students from the National Law School of India University and also Tulane for participating in this workshop and to be part of this valuable conversation. I just caught a little bit of the conversation before you introduced me, and it seemed like it was very interesting. And I'm going to tune in for a little bit afterwards too, so that we can get a sense of what is being discussed. It's a fortuitous time, I should say, because we are just about to mark the 72nd anniversary of India's constitution next week. So having discussions about constitutional law, I think, feels very timely. I'd like to take the opportunity to thank Dr. Sudhir Krishnaswamy and Dr. Jaina Kotari, and also Dr. Aparna Chandra, and of course CLPR for being part of this event today. Thank you. I'd like to personally thank you for taking your time to be with us today and to make this workshop all the more meaningful. And of course, special thanks to Dr. Tushnet for your continuous support for Mission India programs, including the US-India Comparative Constitutional Law programs that you've been part of in 2019 and also coming up this year. So, well, this whole academic year. So we've already gotten a lot of positive feedback for the work that you've done before with the Tamil Nadu National Law University, and also from the presentation you made on the constitutional debates. And from what we understand, students are continuing to use your books and your resources here in South India. So looking very much forward to your continued engagement with our programs in this area. And with that, I'm delighted to pass it back to CLPR for you to introduce our special guest.
Thank you so much. We're actually very excited and privileged to have Professor Tushnet with us today. And I know he needs no introduction, but I'm still going to quickly introduce him to all of you. Professor Tushnet graduated from Harvard College and Yale Law School and served as a law clerk to Justice Thurgood Marshall. He specializes in constitutional law and theory, including comparative constitutional law. His research includes studies of constitutional review in the United States and around the world, and the creation of other institutions for protecting constitutional democracy. He also writes in the area of legal and particularly constitutional history, with works on the development of civil rights in the United States and a history of the Supreme Court in 1930s. His areas of interest include civil rights and civil liberties, civil rights history, legal history, constitutional law, comparative and foreign law, legal history with respect to American slavery and law. Thank you so much, Professor Tushnet, for being here today and taking the time out to address all of us.
Thank you very much for that introduction and for inviting me to participate in this program. As was mentioned, I've done things with the U.S. Consulate in Chennai before and spent a couple of times at the Tamil Nadu National Law School, and found by the time I spent there in India extremely valuable in helping me understand some aspects of the Indian constitutional system. I have to say, as a preliminary to my comments, that although I know something about the Indian Constitution, I can't represent myself as having deep specialist knowledge of its provisions. And so I am actually going to focus mostly on the US Constitution and what it has to say about the topic of executive federalism, that is federalism as embodied in the executive branches of both governments. My introductory observation is that each time that I started to think about this topic, I literally, I started over again each time. And each time I started by thinking, well, you know, the US and the Indian constitutional systems are very different because in the US, this is my initial thought, we don't have the kind of concept of presidential rule that exists in India. By presidential rule, I understand the term to mean the displacement of state level governments by the national executive. But then again, each time I started with that thought, I said, well, actually, there have been examples of presidential rule in a certain sense in the United States. And I want to describe them, at least briefly, as a preliminary, not as a preliminary, but to set the framework for thinking about the constitutional scheme in the United States. So the two major examples of the equivalent of presidential rule both involved episodes in the history of constitutional race relations in the United States. The first occurred after our Civil War ended. And it actually was a fairly brief period for a variety of reasons, in which the period was known as the era of presidential reconstruction. That is, after the Civil War ended, before Abraham Lincoln was assassinated, and then for a brief period during the presidency of Andrew Johnson, the president, Lincoln, and then Johnson directed the installation of governments in the states of the former Confederacy, the rebellious states. Now, I want to note here that, at least as far as I know, presidential reconstruction for this period did not rest on express congressional authorization. I'm going to talk about congressional authorization in more detail later. Rather, presidential reconstruction rested on the president's power as commander-in-chief of the armed forces. The armed forces, the national armed forces, were in some sense occupying the rebellious states, and as a sort of entailment of that occupation, Presidents Lincoln and Johnson installed state governments. Now, that period, I said the period was brief because Johnson adopted a form of reconstruction that was unacceptable to Congress. And Congress enacted statutes that led to a period of what's known as Congressional Reconstruction. And that's different from executive federalism. Okay, so the first period of the equivalent of presidential rule is in the immediate aftermath of the Civil War. The second example involves desegregation of the schools in Little Rock, Arkansas. I need to give you a little background here, not tiny bit about the desegregation matter, and a little more about the organization of armed forces. On desegregation in 1954, the Supreme Court held that school segregation was unconstitutional and directed that states desegregate their schools with, in its terms, all deliberate speed. In 1958, schools in Little Rock were going to be desegregated, but Governor Oliver Forbes of Arkansas obstructed the desegregation in a variety of ways, and that elicited a response from the national government. Okay, now it's the response that I want to talk about as the equivalent of a narrow, a sort of topic-specific form of presidential rule. So here's how things go. The national armed forces of the United States consist of the US Army for these purposes. There's also a system known sort of misleadingly by the name the National Guard, which consists of people who have served in the national armed forces and then have continuing obligations to serve in the National Guard. Again, it's known as the National Guard. Ordinarily, the National Guard is controlled by state governors. That's why the term National Guard is a bit misleading, because ordinarily these are sort of armed forces under the control of the state government. But statutes authorize the US president to convert the state National Guards into arms of the national armed forces. Okay, and then there are the national armed forces. Well, what happened in Little Rock was that faced with Orville Forbes's obstruction of desegregation, President Dwight Eisenhower actually did two things. First, he nationalized the Arkansas National Guard, placing it under the control of the US Army. I'll simplify this story. I should note that nationalization of the state level guards is not uncommon. It is often, typically done at the request of state governors who want to call on national resources to help them deal with natural or other kinds of disasters. So what Eisenhower did in nationalizing the Arkansas Guard wasn't all that extraordinary, but it wasn't in itself an example of a general practice of displacing state level governance, because again, typically when the National Guard is nationalized, it's done at the instance of the state government. The second thing that Eisenhower did, though, was quite dramatic, which was to send units of US national military forces. I think it was an Air Force contingent to Little Rock. And their job was to protect the children who were attempting to desegregate, the African-American children who were attempting to desegregate the Little Rock schools. So there is a presidential decision displacing the state level decision about how to deal with desegregation. Now, it's not presidential rule in the sort of what I understand to the Indian sense of displacing governing power across the board. It's a limited topic desegregation, limited topic displacement of state rule. Okay, so now with that as the framework, what can I say about comparing presidential rule in India and in the United States, now that I've gotten out of my head the idea that we don't have presidential rule in the United States? What are the comparisons? Well, there are, I think, two comparisons. One I'll mention first and then return to, but it's that the occasions for intervention are rare in the United States, and they are driven by what I'll describe in a moment as constitutional concerns about the implementation of the US Constitution. And as I understand things, and this is an important qualification, in India, the occasions for presidential rule have been not as rare. They have been justified by arguments about the necessity to preserve constitutional governance. But those arguments have had a strong partisan flavor. So when presidents have intervened to displace governments, displace state level governments, they've said, I'm doing this because the state level governments are acting in a manner inconsistent with national constitutional requirements or restrictions. But that claim has been, I think, generally regarded as weak and as a cover for partisan intervention. Okay, I'm going to come back to the partisanship point in my last comments on the comparison. The second observation is that in the United States, it's at least, well, it's not at least possible, it is the case that constitutional federalism would operate as a limit on the ability of the president to intervene to displace state level governance. Now, constitutional federalism today, at least, would have two, as a limit on presidential power, would have two components. The first is that with rare, maybe even non-existent exceptions, what Lincoln and Johnson did, that is presidential reconstruction without congressional authorization, would be impermissible. The president, as a matter of constitutional federalism, the court today would say the president could displace state level governance only if Congress authorized it. And in addition, today's doctrine would be that what the president can do or the congressional authorization has to be clear, subject to what we start calling a clear statement rule. And so just to give you an example, there's a statute dealing with the ability of the national government to intervene at state levels called the Stafford Act. It distinguishes between disasters and major disasters. And the president can do things if there's a major disaster that the president couldn't do if there were simply a disaster. So then it becomes important to understand, well, what is the definition of a major disaster? And this has sort of rattled around. It never came to a conclusion, but it's rattled around in connection with the COVID pandemic. That is, there were discussions about whether the president could declare a disaster and then do stuff. And if there were things he couldn't do under the disaster declaration, could he call it a major disaster and then do other stuff? And I don't want to get into the details of it, but the thought was that the congressional authorizations would be different and would be consequential. The president couldn't just say, this is a really major problem, and there's this general Stafford Act rattling around that allows me to do stuff, and I'll invoke the Stafford Act to do it. The president would have to say, no, it's a major disaster, and satisfy whatever legal criteria there are for it being a major disaster, which probably didn't cover the pandemic. Okay, so first of all, there has to be constitutional federalism limits what the president can do because his unilateral power to act is at very least quite narrow. Probably still congressional presidential reconstruction was permissible as a consequence of the commander-in-chief power, but the president can't deploy troops within the United States just because he's the commander-in-chief of the armed forces. And so, again, with the deployment of the National Guard and the Air Force in Little Rock, there had to be statutory authorization for it. Second limit is, again, of constitutional federalism, is that state sovereignty might be a limit on congressional, congressional power to authorize the president to intervene. Now, again, as I understand it, the initial episodes of presidential rule did raise the question of whether there were constitutional federalism limits on presidential rule in India. And again, as I understand it, the Supreme Court said, no, there weren't. In the United States, what would the state sovereignty limit or look like? Or maybe the better way to put it is, under what conditions might the president override state sovereignty in the service of constitutional values? Well, there are two. The first is that the Constitution says that the United States shall guarantee to each state a republican form of government. This guarantee clause, as it's known, would be the justification offered today for congressional reconstruction. That is, the governments in the former states of the Confederacy were not Republican because they were, for among other reasons, continuing to deny the formerly enslaved people a right to participate in the governing process. And that's not a Republican form of government, or just to be as precise as I can, Congress could reasonably think that that wasn't a Republican form of government and invoke its power to guarantee a Republican form of government to justify congressional, in that instance, congressional reconstruction, or to authorize presidential reconstruction. Okay, so state sovereignty limits could be overridden in the name of the guarantee of a Republican form of government. And then secondly, there's again a constitutional provision saying that national law is supreme over state law. And if states are systematically or a state is systematically refusing to comply with federal law, which is applicable to it, that qualification is important for reasons I'll come to in a moment, or a state is refusing to comply with some specific federal law that's applicable to it, then Congress can rely on the Supremacy Clause to authorize the president to intervene to ensure that national law is supreme over state law. And that's what happened in Little Rock. Now, the which is applicable to it point is that it's almost certainly the case, although I don't know that there's a clear decision of law in this matter, that the president, Congress can't authorize the president to act in this manner until there's a judicial decision, maybe even a decision by the Supreme Court, authoritatively saying that the state is not complying with federal law. Once that happens, though, then the congressional authorization of presidential intervention would be permissible, notwithstanding concerns about state sovereignty. Okay, the final point I want to address is something that came up in some of the earlier discussions well, for you this evening, for me this morning, and that is, does it make a difference that the US is a presidential / separation of powers system, whereas India is fundamentally a parliamentary system? The initial slide, or maybe it was the second slide today, said that formally speaking, it's the president who does some of these things. But in practice, the president does so only upon the recommendation of the Council of Ministers, which is to say, the Prime Minister. And therefore, the parliamentarism, presidential rule in India is functionally parliamentary rule. Now, I tried to think this through, and there were suggestions that in earlier comments, that this distinction might make some difference. And I tried to think it through, and I ended up thinking that I couldn't come up with a systematic account of how it would make a difference, how the presidentialism of the US system might affect executive federalism differently from the parliamentary system of executive federalism. And the reason I had difficulty is, again, something that was alluded to earlier, is that these decisions are highly charged politically, always. In the US, Little Rock and Reconstruction were constitutional crises in some sense. They're always highly politically charged. And therefore, you can't think about the exercise of the formal constitutional powers without thinking about the relationship between the formal powers and the operation of the party system. And so in the United States, we've had a stable two-party system with the parties varying, but for pretty much, maybe even for everything, well, let me put it, we've had a stable two-party system since the end of the Civil War. There were instabilities in the party system before the Civil War, but it stabilized after the Civil War. And so then the question would be, well, what happens in a, what happens with respect to executive federalism in a world where you have a stable two-party system? And I guess the answer is probably executive federalism is going to be rare because there are always going to be significant voices in opposition to what the president of one party does. Those voices of opposition will come from the then minority party, which at some point will become the majority party, and the minority party will have some control of some state governments. And so it's going to be hard for the national government to intervene. In India, again, this was alluded to before, I think the sequence has been a dominant party system under Congress party, coalition governments for roughly 20 years, and what now appears to be a new dominant party, although it's maybe too early to say that the BJP is dominant in a way that the Congress party was dominant during its era of dominance, but sort of feels that way now. I guess what you could say is, well, what's going to happen under those situations? If you have a dominant party, maybe it's going to be willing and able to intervene more readily than if you have a coalition government. And that might be the end of what you can say. But the key point here I want to emphasize is that I don't think, so what I've just said is if you have a stable two-party system, executive federalism in its strong form is not going to be common. If you have a dominant party system, then executive federalism in its strong form may be common. If you have coalition governments, it probably won't be. Notice that nothing in that formulation turns on whether the system is presidential or parliamentary. It turns entirely on the configuration of party power. And so in the end, I don't think that, at least at the stage of present thinking, I don't think that parliamentary versus presidential makes a difference in terms of the exercise of at least a strong form of executive federalism. I would want to say, and I'm going to end on this, that I think the German example is something that could be fruitfully introduced into this conversation, precisely because of the you have a stable 2 to 4 party system. It's the number. It doesn't really matter that it's 2. You just need a small number and some degree of stability. With a constitutional structure that builds state governments into the national government. And fundamentally, it's a parliamentary system. And so it would be, I think, interesting to work out the idea of executive federalism in Germany in comparison with the US and India. But I don't know enough about executive federalism in Germany to be able to say anything at all about it. Okay, so I think my time is just about up, and I'm happy to engage in conversation with any of the participants in this, I don't know whether workshop, seminar, whatever. I'm sorry, somebody's just started to use a saw, it sounds like a chainsaw outside my window. And I'm afraid I can't do anything to dampen the sound. Okay, thank you. Again, I look forward to questions and discussion.
Thank you, Professor Tushnet, for your talk. I found the description of the history particularly interesting, the Reconstruction and the Little Rock, Arkansas case. And another thing that I found particularly interesting was the guarantee clause, which I wasn't quite familiar with. So thank you for sort of explaining that so well. Open the floor for questions. Aparna?
Thank you, Professor Tushnet. And before I pose my question, I do want to say this class is a comparative constitutional law class at National Law School, and we've been reading a range of your work, either stuff that you've written directly or other chapters from books that you've edited. So it's a particular pleasure to have you with us in the class. I just wanted to, speak to something that you said towards the end about the party structure in the US and in India and the implications of that and of party politics in how federalism, particularly executive federalism, plays out. And I wondered if it's just a factor of a multi-party, of India being a multi-party democracy, or the fact that at least post 1980s onwards, there's been a regionalization of political parties with the breakup of Congress's dominance and the growth of regional political parties that has shifted the balance in some senses, or at least redressed some of the imbalance between the federal and the state governments, so that after the excesses of the emergency and perhaps a few instances in the 1980s with the Congress government, there's been a delegitimation of the use of presidential rule for purely political consideration. So if you look at the use of presidential rule after the 1980s onwards, it has by and large been only for for situations where the state government just cannot function because no party has a clear majority. So the administration has ground to a halt, as opposed to the kind of situations that one saw when the Congress party was dominant, which was about a pure political sort of use of presidential rule. So I wonder if it's just about multi-party democracy, which was there from the very beginning, even when the Congress party was dominant, to the fact that there's been a shift in the nature of the multi-party democracy over time. And in that sense, would it actually be closer to Germany, even more than what you're suggesting, because of this regionalization of political power?
Yeah, so that seems right and interesting to me. I suppose the only question I have is that I literally don't know enough to have a view on this, whether the regionalization of parties occur. Well, it did occur at a time when at the national level there were coalition governments, And what I would want to know is whether, if it's the case that the BJP has become a national dominant party in the way that the Congress Party was, whether the BJP will be able to or will want to intervene against coherently organized state governments controlled by regional parties not aligned with the BJP. And I just don't know that. And I don't think we know enough, I don't think we know even now whether the BJP is in the course of becoming a dominant party in the way that Congress was during its period of dominance. I think from an outsider's point of view, it sort of looks like it is, but maybe insiders in India would have a more qualified view of that. But I think your point is absolutely clearly right, certainly during the period of coalition governments. And maybe, it'd be an interesting constitutional development to see what happens if the BJP does start to intervene where there's coherent, organized government, regional governments.
Should I step in? Hi, Professor Tushnet. My question was in terms of what we discussed earlier. One of the themes we discussed was a global expansion in executive power. And at least like when we look at its practice in India, one thing that we see is that you don't have like blatant misuses, as Professor Chandra just said, of presidential or president's rule powers, right? It's a lot more subtle. And you have instances of, let's say, where the center will, in a slightly creeping authoritarian form, try and intrude on state rights. So it could be like, let's say, investigations, it could be revenue sharing, these kind of ways in which it takes place right now. I was just wondering if you could tell us, do you see a similar trend in the American Constitution or in American political practice, like both under the Trump administration and the Biden administration? And if so, do you think how do you think the American Constitution will respond to such a stress?
So I have two thoughts here. One, it's clear, as some of the earlier slides indicated, the slide from the Constitution Center, there is a much more prominent role for the idea of a powerful unitary executive today than there was when I was in law school, which is 50 years ago. So yes, there is in some sense, at least much more intellectual support for the idea of an expansive presidency. There's also, again, as the slide indicated, significant opposition to that conceptualization of the presidency. And I want to say it interacts, the idea of a unitary presidency interacts in a complicated way with party politics. So the most prominent supporters of the unitary executive theory have been Republicans, and the most prominent opponents have been Democrats. The tricky part occurs when Democrats become presidents. Do they aggressively pursue a unitary executive theory and practice? And what do Republicans have to say under those circumstances? It turns out that President Obama was moderately aggressive in his use of presidential power. President Biden has not yet been as aggressive. I think there are stories to be told about why that is. But in some way, my version of this is that Republicans are attracted to the unitary executive theory because they think that both for structural and normative reasons, Republicans are entitled to the presidency. They might lose Congress occasionally, but they think they're going to be presidents, Republican presidents, for the foreseeable future. Whether that's true or not, I don't know. But that is in my view, that's the belief that Republicans have. And it's for that reason that they're enthusiastic about the executive, strong executive. Second observation is the formulation you used was the global expansion of presidential power. There's also a literature about the global expansion of judicial power. And maybe, what we're observing is just a global expansion of governmentality. And it's a matter of contingent local circumstances where that expansion of governmentality happens to be located at any particular time. Sometimes it's the courts, sometimes it's the president, sometimes it's going to be the legislature. That's just a thought, but I guess I wouldn't want to commit too strongly to the idea that there's a distinctive phenomenon of global expansion of presidential power. After September 11th in the United States and the development of the international concern about terrorism, there's a large literature about expansion of presidential power in emergencies like terrorism. Then along comes another emergency, COVID, and it turns out that some presidents actually don't want to exercise power under those circumstances. Trump didn't want to do it in the United States. Bolsonaro didn't want to do it in Brazil. And I have the sort of sense that Modi didn't really want to do it in India. Maybe that's wrong about India, but certainly, so there's an interesting article about executive underreach during COVID. And so that sort of leads me to be sort of skeptical about the idea of a generalized expansion of presidential power.
Thank you, Vishank. Yeah.
Hi, Professor Tushnet. So I had a question and I wanted to get some of your thoughts on the difference between India and US on this issue of presidential rule that you were talking about. So there are two differences that I perceive of, and I just want to see what you think of this. So the first thing is you talked about how in the US, one of the justifications for presidential rule can be under the enumerated powers where the federal government sort of has the power to call upon the militia when there's an insurrection or where national laws aren't being followed. And to me, one of the biggest differences that I see with that understanding of the center coming in as opposed to India is that in India, it's not just about calling upon the armed forces, but it's also about powers of governance of the state itself. So in that sense, I think the US Constitution doesn't envisage a situation where there is governance of the state, even when there are issues of, say, the state not following central laws in the way that the Indian Constitution does. And then the second difference, and perhaps this is a bit of a contradiction in that because in India, we see the parliament as having a lot of powers. See, in India, the power of the president to come in under Articles 355 and 356, they're solely vested with the president. So in that sense, from my understanding, the Parliament of India couldn't pass a law regulating the president's power to come into states. On the other hand, as you say, with respect to nationalizing the guard, that is right now controlled by a law passed by the Congress. So in that sense, it seems to be in the US, the Congress can exercise certain powers of regulation over when the federal government can come in, powers which perhaps under the Indian Constitution, the Indian Parliament wouldn't actually have.
Those are both really interesting observations. I think on the first one, the special role of the military in the United States is probably just a contingent fact. That is, that if the circumstances were such as to lead Congress to pass a statute authorizing the president to install a civilian government in a state, I think that would be permissible in the United States. It just hasn't happened in the United States because these interventions have been rare. But I don't think that the military component of it is tied to any constitutional component. On the legislative regulation, so that seems to me, your textual analysis seems right. That is, in the United States, the doctrine would say Congress has to authorize these interventions. In India, the Parliament has no role and might even be prohibited from attempting to regulate these interventions. But given this gets complicated, but the first cut would be, given that the president acts under the guidance of the Council of Ministers, effectively, there is, at the moment, parliamentary control over what the president does. The tricky part is, well, suppose you have a statute adopted, I'll put it this way, during a period of coalition government, attempting to regulate the presidential exercise of presidential rule, and in comes a government different from the coalition government that enacted this stuff, and it wants to intervene in a way incompatible with the enacted statute. I don't know what would happen. I can imagine decisions by the Supreme Court saying that presidential rule can't be constrained, but I could also see decisions saying it could be constrained under those circumstances. Most of the time, it's not going to matter because this particular configuration is not likely to arise very often. Okay, thank you.
Thank you, Professor Tushnet. I think that's a great place to end this session if nobody has any further questions. I'd like to thank the US Consulate for their support, specifically Ms. Usha Davlor, as well as Scott, who's tuned into the session, and Professor Tushnet, Professor Adam Feebleman, Professor Chandra, and Professor Fetke for being a part of this, not just tuning in, but also contributing to this and making it a much more enriching session. I will quickly wrap up this session. Before we end, I thought it would be important to introduce an essay competition that we have as a part of this workshop. So we're conducting an essay competition of which the top 3 winners from all 4 workshops that we've conducted will be winning a cash prize. And the top 2 essays from NLSIU will be invited for a closing ceremony that will have US consulate officials, eminent academics, as well as social activists. This question will be sent to you by mail at 11 a.m. on Sunday. And of course, it's a free-flowing essay. The rules will be mentioned in the mail, and you have to send in your answers by 12 p.m. That's within an hour, to the same ID that we send the question to you from. If you have any questions, feel free to contact either Malvika, me, or Varsha, and our email IDs are available on the website, or you can even write to the email that we send out to everybody. And for purposes of attendance, we actually have a feedback form. So if you guys could fill that, we'll use that to mark attendance as well. And I'm just sending that on the chat to everybody.
I should just clarify that the essay is not part of the evaluation for the course. We had earlier thought that we would combine the essay with course evaluation. Since our exams are not happening right now, the essay is not part of the evaluation for the course. But I encourage you to take part in it. Yeah.
Okay, while you're filling that in, I'd like to thank all the students for being a part of this session and the other 2 sessions, part of the entire workshop. For any more information, feel free to visit our websites. That's the CLPR website, Supreme Court Observer, which is a sister organization of CLPR, as well as the Constitution of India.net website. We encourage you to take part in the essay competition. Feel free to use all the material that we provided to you and more if required for the essay competition. Thank you so much.
Thank you.